So I'll call the Secretariat to give us the directions and whether which one we are starting to admit, because we are going direct to presentation from stockholders. Thank you. Understand we are calling all of them to come to plenary, the sergeant. So thank you very much. I'd like to take the opportunity to welcome everybody in the parliament. This is the premise of parliament. The procedure is parliamentary and everything we are doing here is per the rule of the parliament. So I'd like to confirm the presence of the following before we proceed. Kenya Law Reform Commission, are they present?
Yes, they are present.
Thank you. Kenya National Commission on Human Rights.
Yes, we are present.
Thank you. Kenya Associated Private Employment Agencies. Thank you. ASMAC. Thank you. Kituo Chacheria. Thank you. Is there any group which you hear your name you are not heard here? Any group? So there is this group. Can you be in mic?
Uraia Trust.
Uraia Trust. You can write there. Thank you. I think now we are in order, so I'll call every group to introduce his team. I'll start with Kenya Law Reforms. You can introduce your team.
Thank you, Chair. My name is Thuranira Katoyo, Principal Law Reform Counsel from Kenya Law Reform Commission. Thank you.
Any team?
Yeah, my CEO is in another committee. I think it's the same all.
Okay.
So he will join us just shortly.
Thank you. You involve us when he comes. Kenyan National Commission on Human Rights.
So, thank you. Sorry, I was focusing on the...
Can you introduce yourself and your team?
Okay, thank you, Chair. My name is Commissioner Sarah Bonaya, working with KNHRC, and I have my team here. They can introduce themselves.
My name is Lucas Kimanthi, an Assistant Director at the Kenya National Commission on Human Rights.
Good morning, Chair. My name is Elijah Kandia, serve as a Senior Human Rights Officer with KNCHR.
Kituo cha Sheria. Can you be on mic? On Azad?
Thank you, Chair. My name is Margaret Kemuma from Kituo cha Sheria. I'm here with my colleagues. Richard.
Morning, everyone. I'm Richard Musyoki from Kituo cha Sheria Forced Migration Program Department.
Good morning to you all. My name is Teddy Joseph Ochengo Ndhiambo. I'm an advocate of the High Court of Kenya. I work at Kituo cha Sheria.
Kapea.
Thank you, Chairman. My name is Sarjuma Omar Mwangala, Chairman Kapea, with my legal advisor, Wangoi.
Can you be on mic? Can you sit where there is mic? Sergeant, why are they not sitting those back 3 chairs there? I think they can sit there. In a bit. Oh, is there no chairs? It's empty. No chairs, just empty. So can you sit somewhere you can access the mic? The chairs access the mic, but we are okay. Now you can introduce yourself.
Thank you, Chair. My name is Wangoi Kamau, Advocate of the High Court of Kenya for Kapea.
Thank you very much. Anybody who has not introduced him or herself? Okay, you can.
Thank you, Chair. Deputy Secretary General ASMAC.
Thank you, Chair. Organizing Secretary for ASMAC.
Thank you, Chair. I'm Mase Kawara, Deputy Organizing Secretary for ASMAC.
Thank you, Chair. My name is Hanan Jerry, Trustee, Kapea.
Thank you, Chair. My name is Grace Alan, Kapea Trustee.
Thank you, Chair. My name is George Kinyua, Executive Member, Kapea.
Thank you, Chair. My name is Mundia Mwangi, ASMAC.
Thank you, Chair. My name is Nancy Akinyi from KNCHR.
Thank you very much. Having now been there, I feel everybody has given the chance to introduce himself. Honorable James Koyo, can you put your name in?
Honorable James Koyo, Member of Parliament for Moroni constituency and a ranking member of this committee.
I think Honorable Donya is done online, but you can see to it again.
Good morning, Donya Doris Saburi, member of this committee.
Thank you. Now we are in order. We'll go direct to introduction. Thank you very much again for everyone who has come. You know, we are Kenyans, and Kenya is our country. We are proud of our country. And I think this bill, the labor migration bill, is only to give the right to migrant workers, recruitment agencies, employers in their host country, our government, and the host government. So we are looking for the best labor practice for our people, for the recruitment agency, for the government, and for the employer the other side. So, and they think that's why we are here. So I'll go direct to calling the Kenya law reforms. We can start with Kenya law reform as we indicated. You can proceed by submitting your documents to, I hope you have enough copy because of all I think the stockholder need to have copies. So you need to give copies, then we go direct to your presentation. How many minutes do you want to take?
Thank you, Honorable Chair. Maybe I'll take 15 minutes.
15 minutes, eh?
Yes.
Okay, proceed. Proceed.
Thank you, Chair. I think we have enough copies for members and even stakeholders.
Yeah, give stockholder. Make sure they have copies. It's very important, eh? Yeah.
We had supplied them to the Secretariat. Yeah.
We are okay? Thank you. Proceed.
Thank you, Honorable Chair. So the Kenya Law Reform Commission appreciates this invitation to contribute to this important bill and submit the views. At the outset, the Commission recognizes the importance of the legal framework for fair and safe labor migration, because we know that overseas employment has become a very important component of Kenya's employment policy. We also know that the sector presents some serious regulatory risks, which have been highlighted, including the fraudulent recruitment, charging of unlawful fees, passport detention, and even trafficking-like practices, which really require some attention. Therefore, Honorable Chair, the Commission supports in principle that the policy objective of strengthening the protection of Kenyan migrant workers and regulating the recruitment of foreign employment. However, having said that, Honorable Chair, upon review of the bill from the Senate, in its present form, the Commission views that it raises some substantial constitutional, institutional, and drafting concerns, and therefore we will be recommending that the bill should not be progressed in its current form. And Honorable Chair, we have 9 issues which we want to bring to your attention, which militate the progressing of this bill. Honorable Chair, if I proceed to issue number 1, is the constitutional usage of word deployment. Honorable Chair, clause 5 of the bill, and which is the underlying philosophy of this, says that the government shall deploy migrant workers. Honorable Chair, the Constitution guarantees every person has a right of freedom of movement to leave Kenya. The right to leave Kenya cannot be neutered, and if that right has to be restricted, it must be done so strictly in adherence with Article 24 of the Constitution, which has the provision on how we can limit the right. So therefore, the state may facilitate migration, regulate private employment, or prescribe pre-departure orientation. But the state has no business of saying it will deploy citizens. The deployment aspect or the deployment provisions is for the public officers, diplomatic personnel, and members of disciplined forces. It's not for individual citizens who are seeking employment elsewhere. If they have to go and seek employment elsewhere, then they have a right of leaving the country, and therefore usage of the word deployment and the concept of deployment and even that philosophy is unconstitutionally unstable. And therefore, Honorable Chair, we are recommending the deletion of clause 5 and all its attendant provisions relating to deployment of workers, which runs through the bill. Therefore, Honorable Chair, that's our concern number 2, or number 1. Honorable Chair, our concern number 2 is the scope of this bill. The bill is on its long title was supposed to provide issues of labor migration. However, in the drafting of this bill, the sponsor of this bill seemed to have lost legislative focus. It is more of a bill on everything relating to foreign affairs. Therefore, it stayed beyond the scope. Honorable Chair, and just a peruse of it, we will see provisions on county operating license, on county investment program, on diaspora investment, on national honors, on broad functions of the Cabinet Secretary for Foreign Affairs, labor attaches. Therefore, Honorable Chair, we are concerned that this bill has been turned into an hybrid labor law, diaspora management law, foreign affairs law, county licensing law, and the private employment law. Therefore, it lacks absolute focus, which is necessary for legislation. And therefore, this lack of focus, we are simulating that it will also bring implementation challenges, which will be added later. Therefore, Honorable Chair, if this bill has to progress, we are proposing that it must be limited in scope on aspects relating to only fair recruitment, private employment of agencies engaged in foreign recruitment and pre-departure orientation. Other things, they do not deserve to be in this law, Honorable Chair. Having said that, on that point, therefore we get to the third point, Honorable Chair. Is a standalone act necessary? And it is in our considered opinion of the Commission that we really do not need a standalone law on the issues of labor migration because of the following reasons. The Employment Act itself, as it is, which is a solid act, regulates the foreign contract of service, including signing attestation by labor officers. The Labor Institutions Act provides for employment agencies, including the registration, vetting of interministerial committee. The National Employment Act already establishes NEA, National Employment Authority, and gives it a mandate of employment management. The Foreign Service Act already deals with the Kenya's missions and foreign policy. Therefore, the Commission recommends that rather than having a standalone law, what was required is purely amendment of the existing laws, and would have the labor migration and fair recruitment, maybe amendment bill, which goes on amending the existing law to strengthen the issues of labor migration. Therefore, Honorable Chair, we are also concerned that the bill has substantially deleted provisions in other laws through the consequential amendment, and we are really concerned this is an abuse of consequential amendment. Typically, consequential amendments are supposed to clean up the laws which are existing to be in line with the law which is being proposed. But this consequential amendment, they are purely deleting provisions of other laws without any quality legislative step. Therefore, Honorable Chair, we think this is a misuse of consequential amendment, deleting the provisions of existing law made by Parliament without any value. It's a suboptimal use of scarce legislative resources, and all those consequential amendments is just cannibalizing the existing law and just pushing laws around without any legislative step. We are calling the rejection of all those substantial amendments, the consequential amendment, and also in our view that the standalone law is not necessary. Honorable Chair, we go to our fourth concern of the establishment of a multi-agency committee, which is done in clause 8 to 10. Honorable Chair, the Commission agrees that the labor issues, immigration issues may require some coordination of other agencies, including the vetting. However, the vetting and coordination among government agencies, it's purely an administrative matter. Honorable Chair, multi-agency committees are set up when there is need. They come and dispense on that matter when the need arises, and therefore, when that need arises, they are dispensed with. We have seen multi-stakeholder committee in terms of vetting of cargo consolidation, import, export, the illicit brews. They are all over, Honorable Chair. When you put a multi-stakeholder committee, administrative one, in law, it means you have ossified it to be an institution like any other, and therefore even that be the purpose, because it requires flexibility. Honorable Chair, we are recommending deletion of clause of the entire provision of multi-stakeholder agency committee, because that is an administrative matter which does not require to be done legislatively. Honorable Chair, on the issue number 6, on the private employment agency licensing, the part 3 of the bill has created a registration regime for private employment agencies. However, the Commission knows that the employment agencies are already regulated under the Labor Institution Law, and also some aspects of it are regulated under the National Employment Authority Act. Therefore, bringing them in this law, by just deleting what is there and presenting it, is just a ping-ponging the legal provisions without any legislative step. This creation of new registration regime is a duplication, and it creates a parallel regime without rationalizing what is existing. Therefore, Honorable Chair, we are proposing deletion of entire part 3 on private employment agency licensing, and we are of the view that if there is anything broken in the current law as it is, under the Labor Institution Law or under the NEA Act, those are the ones which should be strengthened, because Parliament already took time in making those provisions. Honorable Chair, I have 3 minutes, so I am going to the 6th point on the county operating license. That is clause 13 and 14. The bill has introduced the county laws in county operating license for private employment agency. Honorable Chair, we are concerned as a matter of policy that the county operating license will create a double licensing regime. It's our considered view that labor standards, foreign affairs, and immigration matters, those are national functions. And if matter is the national functions, then it should not be designated to the county. Counties may support maybe local awareness or data integration, but they should not create a parallel licensing regime. By way of analogy, Chair, if an employment agency is licensed in Kiambu County or in Machakos County, a scope should be purely on that county. Therefore, if it's to recruit people to go to work outside, it should be purely on that county. A county licensing cannot create a nationwide. But now, in terms of policy, that will bring challenges, because if you are an employment agency, it means you must register in every county where you seek to recruit some people to move to other countries, which will create a nightmare in terms of even implementation. Honorable Chair, we are recommending clause 14 be deleted. All the aspects of the county licensing of private agencies be deleted because it's constitutionally under Schedule 4, Part 1, matters of national government, and purely they are not anywhere in Schedule 4, Part 2 on matters of county government. On the second last point, Chair, on labor attaches, which are created, are being established under clause 11 and 12. The Commission is consider that the labor attaches are useful. However, the issues of labor attaches and how you manage emission outside is already covered for in the Foreign Service Act, which was enacted by this Parliament 2 years ago. Then, second Chair, the issues of labor attaches is just one cadre in the HR manual of the Foreign Service. Therefore, it does not require to be legislated because we cannot be legislating cadres which should be in HR manual. Therefore, Honorable Chair, we recommend that that clause on labor attaches be deleted. Honorable Chair, if I go to the second last point on migrants portal and data protection, we have viewed that how the portal has been formulated in the bill, it goes beyond issues of labor. And we are concerned it infringes on the space of Article 1 of the Constitution of the Privacy, because we are really seeking to know every detail of people who are living in country, and the people who are living in country have the constitutional right to leave the country wherever they want, and therefore this portal, in the manner it is coached, is unconstitutional. If we have to create a portal, it must be purely on maybe registration status of the employment agencies and complaints and contact person. But trying to have duplicating an immigration portal on this one, when they don't have authority, we view that portal is overbreadth and unconstitutional. Therefore, Chair, now on the last point, the issue number 9, the bill seeks to criminalize the migration of workers. It says that if you refuse to register, obtain a license as an individual, becomes a criminal aspect. Chair, we are really concerned about the criminalization of migrant workers, because immigrant workers, first of all, they are constitutionally guaranteed to leave Kenya, and all the provisions of criminalizing the migrant workers should be deleted. If the bill has to progress, it should be supportive of migrant workers, and there should not be a criminal statute. Therefore, all the penal provisions, Chair, we seek them be deleted. Therefore, Chair, having said that, what is our recommendation? Our recommendation is this bill be abandoned, and if it has to progress, it should be recast as an amendment bill, and that amendment bill should amend the National Employment Authority Act, the Employment Act, Labour Institutions Act, and Foreign Service Act. In our view, Chair, even though these laws may require some amendments, we find them to be solid in terms of principle. We found their provisions to be constitutionally sound, even though, like any other law, it may require piecemeal amendments depending on how the country goes. Therefore, Honourable Chair, we recommend that this bill, in its current state, be abandoned. Thank you, Honorable Chair.
Thank you very much for your bill and the way you have taken it. And your recommendations are very good, because you know all along when we are doing, I had a lot of questions of the standalone. You tell me to delete, and you already said it will bring a standalone. So can you emphasize on this standalone about this bill? Because you have said, let me check the standalone. You said whether a standalone act is necessary. So do you think it is necessary actually? Forget about your recommendation. Your recommendation has given that answer. But do you think if this parliament thinks to make all those bills you have recommended to stand alone, do you think it will be necessary?
Honorable Chair, we are of the opinion that a standalone law on this is not necessary. Chair, it's not necessary because there is no legal vacuum which Parliament seeks to fill. That because all the underlying issues which are there may already be legislated by this Honorable House. Therefore, what is just required is maybe improving on the existing provisions where they are required to address these emerging issues. But a standalone law, Honorable Chair, in our view, is completely not necessary.
Thank you very much for your presentation. Honorable members, Honorable Kivai.
Thank you, Chair. Again, my name is Kivai Kagesi, MP of Vihiga, member of this committee. I thank the gentleman from KLR for the detailed submission. However, I have 3 issues that I want clarification on. First of all, towards the tail end, you talk about criminalization. I think it's a question of interpretation. I don't think the proposals in this bill are meant to criminalize anybody. In fact, I believe the bill is born out of malpractices which have been encountered. So, I don't know whether you gave a specific examples where the bill is criminalizing the migrant workers. I think it's not a criminal offense to demand a portal, because this is born out of what we are experiencing. What we are experiencing is that these people go out there, they run into trouble, we don't know anything about them. In other words, we have no data. That's what the bill is trying to cure. So it's not trying to criminalize. So I would invite you to rethink what you call criminalization. I think it's just an attempt to right what is wrong. The second point is you've been very wholesale on the consequential clauses. When I go to the consequential clauses of the bill, if you specify, if you look at them, they are very harmless. For example, delete definition of a director. It's just trying to bring a new definition to the director. Things do change. So when I look at all those consequential clauses, I don't see anything particularly harmful unless you see one. Delete words and employment. This is just harmonization of the law. So when I look at all the consequential clauses, I don't see anything really worth what you're saying should be deleted in total. I think that's what I want to have a fine clarification.
Before you come in, the CEO for, I think the CEO for Kenya Law Reform is in. Can you introduce yourself?
Thank you. Good morning, members. Good morning, Chairperson. My name is James Nombi, Acting CEO, Kenya Law Reform Commission. I think I'll allow the officer to proceed from where he was.
Thank you very much. On the rider of that, you can also pin the section which you feel is criminalizing that section. Thank you. You can come in.
Thank you, Honorable Chair, and thank you for the intervention of the Honorable Member. So on the clause I don't have a bill, but I remember the clause very well, that it says that a migrant worker who fails to register commits an offense. I'll get the proper just now. Therefore, Honorable Chair, the issues we had on that is reconciling that with the Constitution, because the Constitution has said every person has a right to leave Kenya. And you can only limit that, because it's a constitutional right, within the limits of Article 24. And Article 24 says you must say clearly the rights which is there and how is limited. Therefore, Honorable Chair, we are saying, even if a migrant worker going to Dubai, even though we understand the concerns, if they refuse to register before they leave Kenya, you cannot create it as an offense, because they have right to leave Kenya guaranteed under the Constitution. So if we want them to limit that right, we should have limited it within the strict provisions of Article 24 of the Constitution, because that's a limitation of right. So that was where I was coming from, Honorable Chair, on that limp. On the second aspect.
Sorry, I can't let you go away with that.
Okay, you can come in, Mheshimiwa.
You are saying if somebody leaves Kenya, goes out there, doesn't register, it's okay, it's in the Constitution. Is that what you're saying? Because what we're saying here, we are trying to address a problem affecting our Kenyans, and we've come up with some rules or regulations. So we're asking people to register. Unless you're telling me to register in itself is against the Constitution. There's something, a mismatch there. I'm not getting it. It's like it is a requirement to register for an ID, to have an ID. So if I say you're not having an ID, then you are committing an offense. Is that wrong? Sorry.
I think you are trying to emphasize on the right of movement through the Constitution. Which article? Can we have the Constitution? Which right give the right for movement? Can somebody read for us? It is within the Constitution. I think the article, the first 20 articles. It is here. You can read for us. You can read to Mheshimiwa, so you can also see any other law which require to register.
Thank you, Honorable Chair. So the article I was referring to, Honorable Member, is Article 39, freedom of movement and residence. Every person has a right to freedom of movement. Every person has the right to leave Kenya. Every citizen has the right to enter, remain in, and reside anywhere in Kenya. So, Honorable Chair, I think it's a legal issue, maybe which we will not have an agreement on. We are saying that if a worker is leaving to Dubai, they are only disciplined in accordance with the immigration law. If you want to limit them in another constraint, which is not immigration law, because immigration aspects are provided for in the Constitution, that's limitation of the right. When a worker is leaving, number one, they are leaving not as a worker, but as a citizen first, who has a right to live. The aspect of worker, them being a worker, is subsidiary. In fact, they have no obligation, constitutional unless legislated by Parliament, of informing the immigration of what they are going and what they are going to do, unless it's legislated for in another law. So that's our position, Honourable Member.
Okay. Want to legislate.
Thank you. Procedurally, that's what we are doing. Your next question, Mheshimiwa. We are in the procedures of the Parliament. We are in the procedure.
What I'm confused about is what he has just read in Article 39, whatever.
Yes.
Nobody is stopping you from going to Dubai.
Yes.
Nobody is stopping you from being there.
Yeah.
But we are saying in our subsidiary legislation that while there, in order for us to protect you, do A, B, C, D.
Yes.
And then we want to do it this is the law. This is the law we want to make. So when you read it, you said unless legislated elsewhere.
Yes.
That's what we want to do.
Honorable Chair, can I?
Donya, do you have to write down that? Thank you.
See, you see, Chair, in the past, we've had workers airing their grievances, which is right. We've also had meeting with the agencies. They've also aired their grievances. So it should be a win-win. they even stated some workers, when they go out, of course you had an agreement of what you're going to do. You reach to that country, and then you start hide and seek from the same agent who had connected you to the people or the workplace where you are connected. So as much as we are here, we want to defend Kenyans working abroad. Let it not be your wish. What you want, you should receive it. And the agent who has taken you abroad, you want, when it is their turn, they be angels. When the workers themselves misbehave. We had a story of Ugandans, and there was another country, was it Philippines? When they go there, they are trained, they have all that is required, but when we come to our country, what they add, some even don't know how to operate those machines and everything. So please, as we do our work, we should also make sure we don't undermine the efforts of the agents. Let it be a win-win.
Okay, thank you. Can you come into the second question for Honorable Kibai before we proceed to the other question? The issue of, I think, the data. There was a question on there was a second question. Can you come?
Yeah, Honorable Chair. So yeah, we understand that the article that the right of movement can be limited, but Chair, what we are proposing is, if it has to be limited, it has to be limited within the Article 24 of the Constitution, which now guides on how you can exactly limit that right. So the drafting of that provision, it needs to be reconciled with the drafting of Article 24, and this Honorable House has done this several times, limiting rights through the Article 24, which has not been done, but if it's done, then it can make that one tenable constitutionally. Thank you, Chair. I think the other issue was the criminalization aspect, which I think I chipped in for the Honorable Member. Thank you.
So thank you very much, Honorable Members. Any other concern to this? This is KL. So I think Kenya law reforms, we are through. Now we can go direct to, thank you very much for your good presentation. We shall retreat and consider all your recommendation. All your recommendations will be treated very important because the matters concerning us as Kenyan citizens. So
thank you, Chair. Let's appreciate our thanks for inviting us, and it was a pleasure engaging you. Thank you.
Thank you. Now we'll go to Kenya law reform. The Kenya National Commission or Human Rights.
Thank you, Chair. My name is Honorable Sarah Bonaya, who is a commissioner with Kenya National Commission on Human Rights. And would want to thank your committee for inviting us into this very important process of looking at this law on labor migration management, which is very key and critical issue bill in this, in this labor process, labor management process. And I want to first, before I deal with the actual issue of I would want to highlight the fact that I worked with the East African community as a legislator for 10 years, and I'm well versed with issues of cross-border rights, and especially labor rights. And Kenya is a consumer and an exporter of labor. So I would wish this bill to look at the issue from both sides, not only as Kenyans, but we also import labor and from migrant communities. So we need to look at it from those two perspectives. As KNHCR, we are supposed to ensure our country complies with international treaties and national and constitutional laws that safeguards human rights. And you know, human rights is cross-cutting in all sectors. And critically in labor law, it's very important to look at our current context as we work on this bill. One, we have very porous border as a country, and we are getting so many illegal migrants and legal migrants into this country. And of course, we have also, our constitution has provided us rights to be able to seek employment elsewhere. So it's very critical. We also know the situation right now happening in South Africa where our citizens are being sent back. So let's be broad-minded when we are looking at it. And as a previous presenter has said, let's also look at the existing laws so that we see whether to put this as part of that law or whether we need it as a standalone. So, and as we have looked through the law, we have given our input, and Elijah, one of our technical staff, will take you through the process. Thank you.
Thank you. Elijah, how many minutes will you take?
I want to seek 20, Chair. Or 15.
No, remember, you want to take 20? No. Can you go with our colleague, formerly colleague? Eh? You work with 15.
Thank
Please.
you very much, Chair.
Thank you very much.
Commissioner. Chair, we went through the bill clause by clause, so I will only limit my presentation to the clauses that where we are making amendments. We'll start clause 2. In terms of interpretations and definitions, we are seeking to expand the meaning of foreign employment to also capture those foreign nationals who are lawfully resident within the country, or and also seeking employment within our territory. Also, we are seeking to have the definition of bilateral agreement be included in the bill, and also the inclusion of a safe house, the definition, because it's also being referred within the Act. On clause 3, Honorable Chair, is we are looking at the bill from a rights-based approach, and so in terms of objects, we are proposing that clause 3E be amended to read to regulate, safeguard, and facilitate safe overseas employment. And the issue here is that we want to prioritize human rights and also human security over the economic remittances that is obtained from these sorts of employment. And also we are seeking to proposing that we amend clause 3H to read promote equal treatment of foreign migrant workers in Kenya who are lawfully engaged in employment. So this is also to provide that coherence and also to include those who are foreign migrants that are working within our territory. Under clause 4, Honorable Chair, that is making provisions for, in terms of the application of the Act, we note that it does not explicitly capture those people who are working within the informal sector, particularly those brokers or persons who are unlicensed, or those who have those briefcase agencies that form bulk of the organizations that work with these irregular migrants. And therefore we are proposing that we amend clause 4B to read the recruitment and deployment of Kenyan citizens for foreign employment, and also the unregistered entities, 4D to read also to include unregistered entities, individuals, informal sub-agents acting as employment brokers. Also, we are acknowledging that there are also those government-to-government agreements that provide labor migration that might lead to labor migrations, and therefore that deployment initiatives also be acknowledged within the application of this Act. Under clause 5, Honorable Chair, on the conditions for deployment of migrant workers, we are seeking to amend this committee to consider the amendment of 5.1 to say that the government shall only deploy migrant workers to countries where the rights of migrants are legally guaranteed and practically protected as verified by other human rights impact assessments. This is because despite many countries still having labor laws, formal labor laws, but the practicality of it, for example, the kafalas, they in a way circumvent them, and we need to have to ensure that where any Kenyan is going, that they are going to countries where there is good labor migration practices that are in line with international labor laws. Also, we are seeking to amend clause 5.2 to read that enforceable labor and social laws that strictly prohibit forced labor, contract substitution, and the withholding of travel documents. These are critical components that affect the rights of those persons who are seeking labor outside, and therefore we've seen various cases of people going in the name of honest recruit, seeking employment only to find themselves in situations where their contracts at the hosting country are substituted or enter into forced labor and have their travel documents confiscated. We are also seeking to amend Clause 5.2c to read an existing bilateral labor agreement in line with international human rights standards, that is, international labor practices. This is to safeguard, to ensure that any bilateral labor agreement that are entered to adhere to our internationally accepted standards. Also, we are seeking to amend, to add a subsection 3 on Clause 5 to read that the Cabinet Secretary shall suspend the deployment of migrant workers to any country upon receiving credible reports of systemic human rights violations or an outbreak of armed conflicts. This is to enable our country to trigger a mechanism where we cease the deployment of labor into such countries, and to have an emergency mechanism where we can have any Kenyan who is outside in a humanitarian crisis be brought back to our country. Under Clause 6, Honorable Chair, we are supporting this clause because it consolidates the regulatory oversight of the National Employment Authority, and we are seeking only to make an amendment to say that the authority shall, in pursuant to the provisions of the Intergovernmental Regulations Act, establish an operational framework within the county governments to set up joint migration registries and decentralized desks is under this bill. So the idea is to have that intergovernmental relations between the county government and the national government, despite the fact that these labor matters are solely the function of the national government, but there is that element of complementarity because these many agencies are operating within the counties, and the counties also have a role in terms of safeguarding their constituents. We are also recommending to add a clause 6.1j to say that we need to register of all suspended and cancelled private employment agencies on the online portal, so that any person can be able to access to establish that if an agency has been blacklisted, then they shouldn't be allowed to operate. This is in line with the ILO Convention in relation to private employment agencies. Honorable Chair, under Clause 7, on the powers of the authority, we are also seeking to seek the amendment that 7E to issue immediate or temporary cease and desist orders to suspend operations and levy prescribed and also administrative penalty to any agency, to the private employment agencies, and also to facilitate forms of dispute resolutions as long as they do not touch on matters relating to trafficking, forced labor, or physical abuse, which are criminal matters. Under Clause 8, Honorable Chair, that touches on the establishment of a multi-agency vetting private of employment agencies, we are seeking that the inclusion of civil society organizations specializing in migrant workers that can be appointed by the Cabinet Secretary or in a manner that they are nominated by an umbrella body or a public benefit organization. Also, we could also have, we are seeking to amend to have the participation of private employment agencies under this in the multi-agency committee, but for them to provide the expert observer and only but to that extent, so that they cannot provide any voting or decision making at that level. Under clause 9, Honorable Chair, on the functions of the committee, we are proposing to add a clause on the functions of the committee to say that the committee, within 30 days of receiving an application from the Director General, will complete the vetting process in its decision in a detailed and reasoned report. This, we are trying to provide that, we are recommending a 30-day timeline so that it becomes efficient and to prohibit the administrative delays or filing judicial reviews. And also, we are proposing to add a clause under, a sub-clause under 9, to have the committee have a function to conduct periodic and announced compliance vetting reviews of any registered agency, and either make recommendations either to suspend or any agency that fails to meet the vetting baselines. This is to provide the swift action and the vetting that is that the committee can provide to protect the rights of labor migrants who might be under distress. The next clause, Chair, Honorable Chair, is clause 12 in terms of the duties of the Cabinet Secretary for Foreign Affairs. We are recommending that the CS in matters relating to the foreign affairs through the Interministerial Joint Committee with the CS responsible for labor to have execute the mandatory consular and administrative programs to secure welfare of migrants. This is to ensure that there is that continued relationship between the migrants and also various consulates. And also we are seeking to amend clause 12(2)(h) to read that in coordination with the authority, seek to execute a single unified national framework for social economic integration of returnees upon arrival in Kenya. This is to ensure that for those who are returning, they can be integrated and also in a more humane manner, and also to in any matters relating to their rights. And also we are seeking to add a duty to the CS responsible for foreign affairs to have that mandatory standing order for all diplomatic missions to render consular assistance, including physical visitation, representation to any Kenyan migrant worker who is either detained, inducted, or restricted from movement within a host state. This is stemming from the various issues that migrant workers experience within their country, and whenever they are in distress, they need that consular support, and this provides that administrative framework to safeguard the same. Honorable Chair, on the role of the county governments, we are seeking to say that we have a simplified, non-chargeable county operational clearance. This will address the issue of the double licensing, and also that if we could have the county labor migration database linked with the national migrant workers portal.
You know, you have only 3 minutes. How are you going to do it? Can you bring the condensers one, then you can leave the one you are supporting? Because now you know you are contemplating that with the whole bill, you have something to change. So can you pin the condensers one? You have no issue. You can, even your 20 minutes, you are not going to finish, I think. So let's give the officer from State Department for Labor to introduce themselves.
Well guided, Chair.
Good morning, Chair. Good morning, members. Good morning, fellow stakeholders who are in this room. My name is Joel Mwanzia, Secretary for Labor Migration Management. I'm here representing the PS, State Department for Labor and Skills Development, Mr. Shadrach Mwadime. I want to say that coming from the Ministry of Labor, and particularly the State Department for Labor and Skills Development, the Directorate of Labor Migration Management, we are the principal, will be the principal implementer of this bill once it is passed. And because of that, the government itself had also, initiated its own bill, which is somewhere along the chains. It's being processed as well. And we've managed to gather wide-ranging views, because the bill has also gone through public participation, and it will be coming also to this House for further consideration. And we, because of that, would have wished to seek for leave of this Honorable House so that we could consolidate the views, the input that is coming from this process, together with what we've been able to prepare in the bill, so that we can have a very enriched and comprehensive bill that addresses the issues of labor migration. And I think many of the stakeholders who I can see here have been part and parcel of that process, and I think in their submissions will also be affirming what we've been able to do. So with your permission, Mr. Chair, we'll seek to leave to submit the comprehensive bill at a time that is convenient to you in the near future. Thank you, Chair.
Thank you very much, and we say guided as committee. You can proceed. Your presentation is good, but save our time. Thank you.
Thank you, Honorable Chair. Allow me, Chair, to quickly go to the clause 14 on the application for an operating license within the county government. Under the county, we are proposing that a 14-day timeline is too long. It is too short for purposes of verification and even to have the background checks, so that it's a rigorous process, and therefore we are proposing that for the authority to consider and inspect, then that should be enhanced to from 14 to 45 days. And then, Chair, Honorable Chair, under clause 18 on the conditions for the registration of private employment agencies, we are recommending that there should be full disclosure of the beneficial ownership and the certified copies of registration and compliance for foreign partner agencies in destination countries. We are recommending this because the disclosure will enable us to the requisite accountability agencies or justice entities to have to pursue these international counterparts and also and help us tighten that cross-border liabilities, that gap that has been within agencies that are foreignly registered. Also, the issue under clause 19 on security bond, we are proposing that every employment agency in the recruitment of workers for foreign employment to have a bond of not less than 5 million or a higher risk, adjusted as may be prescribed. This is to give, of course, the Director General powers to draw upon this bond in particularly instances where we are rescuing and repatriating our migrant workers who are abroad. Then, Chair, on clause 20, on the cancellation of registration, we are seeking to have also, apart from just cancellation, to have a ban on particularly on the directors of these corporate entities from holding any shareholding or any position in terms of private employment agency. This is to secure that if a cancellation has been done, then those individuals should not just morph and form into another agency. This will protect the country from those rogue directors who would, once you're banned here, you just form another entity and proceed on to conduct, and also would disrupt those networks of human trafficking. Under clause 24, we on the approval of job orders, we are while it establishes a gatekeeping mechanism, we are recommending that we should also have a component where the authority rejects any order that has not been, originating from a state that has been suspended by the cabinet secretary under the clause 5. And then in terms of advertisements, because this affects many Kenyans under clause 25, we are recommending that to have a penalty for any person who publishes false, misleading, and deceptive advertisement on employment to commit, and we are proposing a fine of 5 million Kenya shillings or an imprisonment of 5 years. This would introduce a penalty to protect unsuspecting Kenyans from advertisements that would either lead to fraud or would lead to incidences of human trafficking. Also, in terms of Honorable Chair, under clause 34 on the registration of migrant workers, while the previous presenters had raised an issue about criminality, we are proposing that we add a section targeted particularly to recruitment agencies, that any private recruitment agency that deploys a migrant worker without a formal registration would then commit an offense. This would shift also accountability to the recruitment agencies to ensure that all workers that are deployed are also safeguarded or are registered within our country. With that, Honorable Chair, I yield, and we would continue to provide further amendments to this and the substantive memorandum. Thank you very much, and thank you, Commissioner.
Thank you very much for your short presentation. It wasn't short, it was big, eh? But it's good. Honorable Kivai, thank you.
Thank you, Chair. Let me join you in applauding that presentation, very detailed. And in fact, in the write-up, I tend to have ticked so many of your recommendations. But like on under clause 2, the addition of definitions, I think they're useful, safe houses and all that. But I start disagreeing with you on where you want us to add clauses on the definitions. You want us to add 4D unregistered entities, blah, blah, blah. These are the people who are causing all the havoc. Why would we recognize them? These are the people who are unregistered. They are causing all the problems to our workers. We don't recognize them. Why do you want us to recognize them in this draft bill? I really don't think it's necessary. Now, under clause 5, one is it's obvious where you are coming from, because all you are adding is human rights, but I have particular problem with one of them, to do with the countries. A good example, I think I was following a story on CNN one time to do with, I think, Afghanistan. The definition of human rights can be very varied. They gave an example of like ladies not going to school, and they were interfering. They were interviewing or not working or something, and they were giving examples, and they were interviewing the ladies themselves. So this word human rights, we need to be very careful. It's not as standard and it's not universal as it seems. So just adding the word international human rights on every definition gives me a problem, because countries vary. Countries present themselves very differently when it comes to human rights. I totally agree with you on your clause on publishing the list on the portal. Totally agree with you, because anybody can access, and that's one of the problems we have. People don't have this information. So I agree with you on that. Sorry, Chairman, I made my notes on very many pages. I have to look for them. Now, when we go to clause 14, which is your page 8, you are saying instead of 14 days, 45 days. I totally disagree. Because this is the red tape we talk about. We are talking of somebody having made an application. The application has been received in that office, and the law is requiring the CEC to deal with that application within 14 days. I see no problem with that. Because if you give it 45 days, then given the nature of the problem, sometimes people get job offers, and these job offers are time-bound. So allowing a CEC member 45 days, you didn't justify why 45 days. So I would rather we stick with 14 or at most 30 days. That's my view. I hope you're taking notes.
Yes, Chair.
I totally agree with your presentation on clause 24. But what about if this country comes out of the list? Should we make it clear? This is a country that has been suspended, but maybe they go to that list because of a happening, an occurrence. So maybe we need to be clear when that it can, whether it should include details when this person is no longer, or that country is no longer on the list. But I agree with you. I also agree totally with clause 34. Yeah, that's where I had a problem with the previous presenter. Criminalization. So I think we should shift some of this burden to the employment agencies. So I think that's useful. For some reason, you stopped at clause 34. For some reason, I don't know whether it's the chairman.
Yeah.
But you had something to say on 35, don't you? Because it's in your submission. That's all, Chair.
Thank you. Can you expound on the concern?
Thank you. I would invite also my other colleagues to chip in, if with your kind permission, Chair.
Thank you.
We take note of the responses by the honourable member, and we will review our memorandum, and we also take note of the clauses that you agree on the issue about the counties. We also agree with the recommendation that if it extends the limit, the CEC member from, if it is to extend, it could go to 30 days. We agree with that. We want just aware of that vetting of a local application stage, but we are willing to yield on the same. And the other clauses, we stopped at clause 35. We just wanted to ensure that while we agreed with the substantive clause on 35 for the authority to maintain that structured database, we only wanted to ensure that also this information remains classified, in the sense that because it captures the personal data of individuals, and it should be protected so that it does not expose the migrant worker, but only be accessed by foreign missions whenever they are seeking to provide that emergency assistance. So with that, Chair, I yield. If there is any other comment from my colleagues.
Yeah, through the Chair, I wanted to respond to the issue of human rights and the universality, because as a country we are signatories to treaties which are international on human rights. We also have continental laws and the regional laws, and the EAC that we comply with, and on human rights issues. So it's not that human rights is. It is, even in our constitution, we know what our rights, the specific rights. Article 43 is very clear, and all the other articles that safeguards our rights. And it doesn't mean that once a Kenyan crosses the borders, and the human right is human right. Yes, you are a Kenyan, but the other people can also come into our country, and they have rights as human beings because of those other laws. So I think the human right is very, very clear. Those who don't comply with those international standards, of course, they have problems. And those are the issues we are saying. Before we send our people there, we need to be sure that these are countries that comply with set standards and principles of human rights. Thank you.
Thank you very much. Having no another concern, thank you very much for your good presentation. We'll take concern, as your technical team have said, they say they can review, so we can also review on your behalf. So when we retreat, as Honorable Kifai had proposed, I can hear you are concurring in some of the proposal, yes. We shall consider your submission, and you'll be happy to see Kenyans moving out of the country, enjoying their right to work abroad. So thank you very much. We can, honorable members, we need to proceed to the other team. I can see we're having Kituo cha Sheria. No? Can you come in?
Thank you, Chair and honorable members of the committee, for inviting Kituo cha Sheria to present our memorandum on labor migration and management bill. We appreciate the opportunity to contribute to this legislative framework. And for over 5 decades, Kituo cha Sheria has stood as a premier legal aid and human rights organization. And part of our mandate is to actively advocate for the rights of vulnerable populations, including migrant workers. And we welcome the bill as a timely and necessary consolidation of the law. And we support the bill's core objectives, and our memorandum identifies specific critical and remediable
How many
gaps.
minutes you are taking?
20 minutes.
20 minutes, eh?
Or less.
Okay. So you can sit in to listen, or you can choose to exit, if it's how you feel after you finish your presentation. Continue.
Thank you, Chair. Our memo identifies specific critical and remediable gaps across 2 primary areas of migration governance. The first area is on refugees, and our submission is that the bill as drafted is framed almost exclusively around the outbound migration of Kenyan citizens. It does not expressly extend its protective and regulatory framework to refugees and asylum seekers who are already lawfully present in Kenya. And they're entitled under Section 28(5) of the Refugees Act 2021 to seek and engage in employment. Our submission is that this gap directly leaves out the government's commitment, number one, under the Constitution of Kenya 2010, specifically Article 2(5) and 2(6), which states that the international laws shall also form part of the laws of Kenya. And we also have the government's Shirika Plan, which seeks to transition refugee camps into integrated socioeconomic settlements within the country to enable refugees access county services, local markets, and the formal national labor market. Secondly, our submissions also touch on Kenyan citizens. And here we state that while seeking to regulate the private employment agencies, the text of the bill as it is does not have robust safeguards to protect outbound Kenyan citizens from the systemic Middle East labor abuses, deceptive foreign contract submissions, which are driven by language barriers, and predatory trafficking channels that recruit vulnerable Kenyans into high-risk foreign military or armed conflict zones under the guise of casual labor. Our key concerns are as follows. First, that there are definition gaps in clauses 2 and 4, where the bill's definition of migrant workers and its scope apply only to Kenyan citizens moving abroad. This creates a gap for foreign and refugee workers employed locally, and which also contradicts the equal treatment goal, which is stated in clause 3H. And also crucially, the bill does not define a foreign contract of employment, even though it tries to regulate this later. This leaves a loophole that allows for contract fraud. Secondly, institutional bodies established under the bill, and in particular the Multi-Agency Committee on the Vetting of Private Employment Agencies under Clause 8, does not include the Department of Refugee Services, despite the department holding primary custody of the documentation needed to verify refugees' lawful status. Thirdly, the county level and digital infrastructure, which are in clauses 13 and 15, where the county labor databases and the online migrant workers portal currently do not have a provision where they sync with ongoing refugee local integration programs or alternative state identification like the refugee ID and the Class M work permits. This risks creating duplicate tracking systems and could lock out legal workers who do not have a standard foreign passport. Fourth, the bill's framework for bilateral labor agreements under Clause 43 and subsidiary regulations under Clause 49 do not yet contemplate refugee labor mobility or complementary pathways, which is an area of growing relevance to Kenya's international commitment under the Global Compact on Refugees. Fifth, on the financial rules and agent liability, the current text as it is allows agency owners to avoid personal responsibility when workers end up in danger abroad. The bill does not have clear rules to hold agency directors personally responsible and does not set aside immediate emergency rescue funds for Kenyan embassies and lacks strict contract checks to ensure that workers are paid the minimum wages agreed upon under government deals. And finally, the risk of exploitation and foreign military enlistment, which is covered under clauses 43, 44, and 48, need to be strengthened. The bill's rules don't explicitly ban agencies from deceptively recruiting Kenyans into combat roles and or high-risk security jobs in active foreign war zones, such as joining foreign armies, and additionally, the fines and jail terms for human smuggling or using informal contracts are too low to stop illegal recruitments. I will go directly into the proposed amendments as per the various clauses. Under Clause 2 on interpretation, we propose to insert a new definition of refugees and state that refugee has the meaning assigned to it under Section 3 of the Refugees Act 2021. We also propose to amend the definition of migrant worker to state that migrant worker includes a refugee lawfully residing in Kenya and authorized to seek and engage in wage earning employment under Section 28(5) of the Refugees Act 2021. The second proposal, still on interpretation, we contend that the bill in its whole sense regulates foreign contracts of employment under clauses 30 and 31, but completely fails to define the term in clause 2. And in our humble opinion, this creates a dangerous interpretative loophole. The proposal is to insert the definition of foreign contract of employment to mean that a contract of service entered into between a migrant worker and an employer for employment outside Kenya, which shall be executed in English, Kiswahili, and a language understood by the migrant worker, with all versions holding equal legal status. And this is basically to guarantee statutory protection against language barriers and deceptive contract substitutions. Under Clause 3H, we propose to amend Clause 3H to read as follows: promote equal treatment for foreign migrant workers, including refugees and asylum seekers lawfully present in Kenya who are lawfully engaged or seeking to be engaged in employment consistent with the Refugees Act 2021. And the justification for this is that if we express this referencing directly, it removes that ambiguity for the National Employment Authority and county licensing officers. And in doing so, we also anchor the bill within the government's Shirika Plan policy, which is on transitioning refugee camps into integrated settlements with formal access to labor market. On Clause 4, the Act applies to private employment agencies, recruitment of Kenyan citizens, migrant workers as defined. Then the domestic recruitment of non-citizens, including refugees, by registered private employment agencies is not addressed, and yet the bill talks about foreign migrant workers within Kenya. The humble proposal under this particular clause is to insert a new paragraph, 4D. The recruitment by a private employment agency under this Act of refugees and other foreign nationals lawfully authorized to work in Kenya for employment within Kenya. Under Clause 8, on the multi-agency committee on the vetting of private employment agencies, the proposal is to amend Section 8 by inserting a new paragraph, I. A representative of the Department of Refugee Services, nominated by the Principal Secretary responsible for refugee affairs, as a substantive member of the committee. The committee, as is composed currently, does not have representation from the Department of Refugee Services. Clause 13, which requires counties to establish a database of migrant workers and develop county-specific investment reintegration programs, does not have reference to refugee populations already resident within their jurisdictions. And the proposal is to insert a new paragraph, G, which states that in refugee hosting counties, incorporate registered refugees and asylum seekers lawfully authorized to work into county labor databases, investment and employment programs developed under this section in line with applicable county refugee integration strategies. This brings the bill into alignment with the already ongoing efforts in devolution and integration initiatives, which also includes Nairobi County Integration and Community Building Strategy and similar county level frameworks anticipated or those which are already underway under the Shirika plan. For instance, the Garissa and Turkana, Garissa and Kalobey socio-economic development plans, and this is to ensure that county labor planning does not overlook a population that is already legally entitled to work under the Refugees Act. Clause 15 on the migrant workers portal, we humbly propose to insert a new section stating that the authority shall, in collaboration with the Department of Refugee Services, ensure that the portal established under this section is interoperable with existing refugee registration systems to enable refugees and asylum seekers lawfully authorized to work to register as job seekers without duplicative documentation requirement. The justification for this is that this safeguards digital inclusion. It ensures that the automated systems within the migrant workers portal do not lock out authorized refugees who are registered and documented by the Department of Refugee Services. The next clause is clause 19 on security bond, where the clause leaves the value of the financial escrow security bond fully discretionary for the Cabinet Secretary. The proposal is to amend clause 19.1 by adding a new proviso stating that provided that 30% of the bond shall be held as a liquid cash escrow to be utilized immediately by Kenya's foreign missions for emergency rescue, shelter, medical treatment, or safe repatriation of distressed workers. When workers face immediate dangers of physical abuse in destination countries, Kenyan embassies often claim that they lack immediate discretionary budgets to rescue them. With this kind of provision, it will make emergency funding immediately accessible to rescue those that are in distress or in danger. Also, clause 27 on obligations of PEAs. Agencies are required to monitor workers, although there is no direct penalty if they actively ignore a distress call from a Kenyan. PEAs can currently shield themselves behind the corporate shell if a worker faces human rights abuses under their watch. The proposal is to amend clause 27.1 by adding a new paragraph, F, which states that establish an active 24-hour distress reporting system and provide a formal documented response on intervention within 48 hours of receiving an emergency report, and also amend clause 27 by inserting a new sub-clause 3. A private employment agency and its directors shall be held jointly and severally liable alongside the foreign
Kituo cha sheria. The story is good, but the time is not promising. Can you bring the condensers? Because I think you have only 4 to 5 minutes. Bring the condensers, because also the question need to be within your 20 minutes. Thank you.
Noted, Chair, and thank you for that direction. Clause 27, insert a new sub-clause 3. A private employment agency and its directors shall be held jointly and severally liable alongside the foreign employer for any gross labor exploitation, unpaid wages, or physical injury resulting from contract violations. Clause 31 on the role of local attestation of contracts, we propose adding a new paragraph D. The basic wage and working conditions stated in the contract meet or exceed the minimum threshold negotiated under the bilateral labor agreement. And also on registration of migrant workers, which mandates the strict registration procedures for all migrant workers, creating a duplicate hurdle for individuals who are already heavily vetted by state security and immigration. So this is basically to bring the refugees under this particular clause and amend the section by inserting a new proviso, providing that the registration process for a foreign migrant worker who is a refugee shall utilize existing statutory registration data held under the Department of Refugee Services. Clause 41 on restrictions on labor migration. The submission is to insert a new paragraph where the targeted occupation involves combat roles, active military operations, paramilitary duties, or private security deployment in an active foreign war zone, conflict zone, or unrecognized armed force. This prevents vulnerable Kenyans from being used as mercenary forces. Clause 43 on bilateral labor agreements, we propose to insert a new guiding principle under subsection 2H to include facilitation of complementary pathways for refugee labor mobility, consistent with Kenya's commitments under the Global Compact on Refugees, Global Compact for Migration on Refugees. This positions Kenya to use BLAs as a vehicle for refugee skills mobility.
Section are you now?
Clause 44.
44, you are remaining with. I think I did not see the other remaining being contentious, and there is something I need also to request for submission. Can you go to conclusion? Or maybe do you think any clause they are very contentious which you need to bring?
I believe the other clauses have been addressed by the speakers who went before me.
Good.
So we humbly submit.
Okay.
Thank you,
For
Chair.
my concern is on your conclusion. There is some you take Kituo through the Law is stand ready to provide any further technical input. Actually, that is our concern as a committee. You are talking about the refugee to be employed here in Kenya. You need to brief us how you want to be undertaken, and we can have more interactive with your team to give us those guidelines. So we leave it. Okay, Honorable Okibai.
I just want to ride on what you've just said, and is the whole focus of the presentation. This presentation is a mouthful on refugees. Now, the question is, when I look at what we are defining as a migrant worker, it starts by meaning a Kenyan citizen who blah, 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 blah. So are we really addressing the problem? With this bill, we are trying to address the issues of Kenyan citizens going outside the country. Now, we need also to define your refugees. Do they come in that categorization? Because we might be trying to force some people in this category who are not being addressed by this bill. So I think it's very important to define who is a refugee. My understanding of a refugee is somebody who has come into this country, not necessarily, in fact, by definition, not a Kenyan citizen. So he falls outside our scope. So you need to be very clear on this. And maybe let me take this opportunity to just finish my other question.
Okay, you can.
My other question was, you want us, in the committee, you want somebody from Department of Refugees to be represented. Now, I see the Department of Immigration is there. Forget about the current executive order. Executive orders do change. So, do they not fall under immigration? So if that's the case, then your submission falters. Thank you, Chairman.
Actually, in addition to what Okibai have said, we don't want to be ambiguous or bring conflict of law. We can still treat the bill for refugees as a bill when we want to bring the matters of labor. So that's why my wish, if you want your attention for this committee to address matters of refugee in employment, can you bring it rather than to force it in this bill? Because by putting it here, you start putting, I know the State Department for Labor, they are here. If they start telling about foreign employment, for a Kenya foreign employment, I know you are talking about the refugees with IDs. So can you give us more update? If you can come and show us the refugee, they can have their own bill, given the right to work here in Kenya. Thank you.
Thank you, Chair, and Honorable Member, for your questions. As you've rightly put it, the bill in its definition addresses Kenyan citizens who are going to work abroad or outside the country. But then one of the proposals that we have is to also expand the meaning of migrant worker, because under section clause 3H, it talks about foreign migrant workers who are also working in Kenya. But the text of the bill as it is does not regulate the foreign workers who are legally here in Kenya. So our proposal is to include refugees who are lawfully residing here, because they fall under the definition of foreigners who have come into the country. And the reason that we humbly making this particular proposal is that refugees have been here for a very long time. We have a protracted situation in Kenya, and as we know, we have 3 durable solutions. One of them is resettlement to a third country. Secondly is voluntary repatriation if their countries are safe for their return. And then thirdly, we have local integration. So there have been many efforts around local integration to try and see how refugees can be locally integrated and how they can be allowed to work legally in Kenya.
Good. Let's go with your conclusion. Yes. You know what you have said? The Kituo through the Rawi East Africa stand ready to provide. We go with that. Yes. So thank you very much, honorable members. I think we have only 22 minutes. So we have 3 stockholders remaining. So we have to limit the time. We don't need to look to be fair, but we have to listen to everyone. So we limit the minutes to 7 minutes. Kituo cha Uraia, you have any submission?
Yes.
Okay.
But I'll just do an overview. Then
Yes. Thank you very much. Thank you.
Written submissions later. Maybe just to start, under clause 2 on interpretation, the definition of a labor attaché is tied to clause 10. However, when you look at clause 10, it talks about reporting. So actually the correct reference should be 11. So maybe just to note that as we continue. The other aspect is on objectives. Clause 3, we recommend that we need to insert an objective K, maybe probably to talk about aspects of gender equality and discrimination. Specifically, we argue this because in 2019, the Kenya National Bureau of Statistics noted that 60% of Kenyans who are labor migrants workers are actually women. And maybe given that the purpose of also our legislation is to solve a problem, we might also want to deal with that. Also, we put emphasis on the missing definitions that we feel like ought to be there. For example, we need emphasis on what bilateral labor agreements are, safe houses, and also the aspect of the migrant workers welfare fund. We note that in the initial memorandum, I don't know if the memorandum has actually changed, but we had aspects of where we talk about a fund. I think I will address that when I come to that question. The other aspect is on clause 5. Clause 5, it sets the conditions for deploying workers, but it doesn't contain aspects on disclosing of publicly disclosing the countries that have been approved. So our recommendation is probably the cabinet secretary should actually annually publish in the Kenya Gazette and on the authority's website of an updated list of countries, and then of course also provide all the bilateral labor agreements. Moving on to clause 6, it creates extensive data collection obligations, but we want to ensure that we abide with the law on data protection. Therefore, we recommend that all the personal data collected should also be processed and worked upon in terms of the guidelines issued by the Data Protection Commissioner. Moving forward, on the aspect of Clause 8 for the membership of the committee, we note that there are no representatives for the actual workers, so we note that there are various migrant workers representative groups. For example, we have examples of Kudeya who have aspects of that. So maybe if we could add a representative of the associations of Kenya migrant workers or diasporas workers there, that could benefit, because we are talking about private recruitment agencies being there, so it's only fair to have them there. Then of course, emphasis there, we talk about the multi-agency committee should have aspects of gender balance. I think just to emphasize on that, we need to be very clear. Then going still the membership, we might also want to expand the membership to also have aspects of the Kenya National Human Rights Commission, or even NGEC, or members of the civil society to be involved there, because the civil society has actually been working around this space, and we feel like there are aspects that they could contribute towards implementation of the law. Maybe just I would want to skip to specifically yes,
you can come to critical omissions, maybe. Actually, the others, okay. they are good, and they're self-explanatory.
Okay.
When we treat the others, we'll be able to get them. But this critical omission and omission, because you're put in red, can you emphasize on it?
All right. So on the aspect of critical omission, we note that when you look at the memorandum of objects that was provided for, it has reasons, and explicitly under Part 6, it provides for the establishment of the Migrant Workers Welfare Fund. Under the Public Finance Management Act, there appears to be no provision specifically even simply of establishing that fund. Maybe we could get clarification on whether or not that still continues. If that's so, we recommend the insertion of probably a new clause that would be Section 48A under Part 6, and that would talk about the establishment of a fund. And thereunder, this new clause can talk about the administration of the fund, the levies from the agencies, any emergencies that can be sorted around that, and probably death benefits. The justification you're giving that is that this is a global standard, and we've actually seen the Philippines, Sri Lanka, and also India give that. Also, if you look at the Kenya Diaspora Policy 2022, there's a commitment by the government to establish such a fund. So it's actually such a reference to such a fund missing in such a critical bill would undermine the bill's protective purpose. So that's it, I think, from our end, given the issue of time.
Thank you very much. You are Kevin Muiruri.
Yes.
Thank you, and a good presentation. Next time when we treat, we shall, maybe you follow us. We can still give you more time when we are reaching for this bill. You can still come and elaborate more.
Okay.
We are still open to listen because you already submitted your memorandum.
Yes.
So we'll go direct to Kapea. Thank you.
Thank you, Chair. In light of the fact that there is little time left, I'll go directly into presenting our proposals and recommendations. So I'll start off with Clause 8 on the composition of multi-agency committee. We observe that there's a provision for inclusion of the agency representative, private employment agency representative. We wish to comment that we find that to come out as a conflict of interest because this is not an, the multi-agency committee is not established for purposes of advisory or consultancy purposes, but it is established for purposes of vetting. So we find that it will cause a conflict of interest to have the agency representative in the same. On to the second point, clause 13, on the county labor migrations functions. We propose that the clause be deleted in its entirety because labor migration is not purely an employment issue. It involves foreign affairs, bilateral agreements, immigration, international relations, which are all functions of the national government under the fourth schedule of the Constitution. So we believe that having the county government coming in these functions, it will create duplicity, where we see that they have to create county databases, promote foreign employment opportunities, and have separate reintegration programs. So our proposal is that rather than creating new structures, existing resources can be concentrated within a coordinated system. On clause 30, subclause 3, on the liability of private employment agencies, there is a strict and unlimited vicarious liability imposed upon private employment agencies for contractual breaches committed solely by foreign employers. So we recommend that private employment agencies only be held liable for breaches arising directly from their own negligence, fraud, or misrepresentation. And to add something that was mentioned by one of the previous presenters, that it would be best that if we also had documents and all registration documents from the foreign employer, so that we're able to also hold them accountable instead of placing all their liability on the private employment agencies, which are a bit limited once the migrant workers are already in the other countries. The next point is on recognition of modern employment agreements. The bill is static on the employment relations, and it limits the term of employment to only salary-based contracts. We'd like that perhaps it would also appreciate and incorporate employment structures that arrangements that are commission-based and locum-based, because some of the industries provide for locum-based employment. They provide for locum-based positions and also commission-based, such as the medical field for the nurses, the doctors, and also some of the fields provide for commission-based opportunities, including consultancy positions and in the real estate industry in specific. Then the next point is on certification for employment contracts by migrant workers. Clause 34 requires migrant workers to register with the authority and submit an attested contract. However, it lacks an explicit mandatory prohibition against departing the country without obtaining official clearance. We believe that this will also act as a control measure to curb human trafficking and ensure that all the migrant workers, before their travel, they have confirmed and ensured that their certificates have been attested, and they have, their contracts have been attested, and they have also been issued with a clearance certificate to ensure that there is a balance struck between the liability and the responsibility placed on the agencies as well. Then clause 41 on the restriction of migration by the cabinet secretary, as opposed to the current blanket ban that occurs. We propose that any restriction imposed by the cabinet secretary should be mandatory to written consultation with the multi-agency committee, the National Employment Authority, and all other responsible stakeholders, and also approval by Parliament within 14 days of issuance. The next clause that I'll address is clause 42 on the repatriation of migrant workers. The bill solely places the burden of repatriation upon recruitment agencies, and we have to understand that some of the causes of repatriation are beyond the control of the recruitment agencies. So we believe that it would be best that if there is established a structured shared responsibility framework utilizing core contributions from the foreign employer, the agency, and also establishment of government intervention funds during these distress times. My second last point is inclusion of a new clause on the liability of migrant workers, which we believe will serve as a deterrent measure for all migrant workers who who are involved in misconduct with the knowledge that they will not be held liable for any of their actions. We also need to recognize that some of the actions of these migrant workers come in to affect the agencies. So it will be best that we provide a clause that the bill includes and inserts a clause under the offenses and penalties, part 5, to include penalizing or punishing any migrant workers who conduct any misconduct with their knowledge of the same. And then finally, on the issue of penalties, inconsistencies, we've noticed that the bill provides for penalties on various sections. However, we recognize the need for harmonization of those penalties and of those offenses by creating tiers, such as having the tier covering the administrative violations or anything that fits in that category, another tier covering the regulatory and non-compliance offenses, and finally a third tier covering the fraud or illegal recruitment and serious harm to workers. Thank you.
Thank you very much. In order to conclude very easily, I propose ASMAC to come together. At least now we can intercept the same stockholders. ASMAC, thank you.
Very well, Chair. On behalf of ASMAC, I'm going to present our clauses by clauses proposal. We start with clause number 6.
Point of procedure.
Okay.
Maybe before ASMAC makes their presentation, could they tell us the difference? The ASMAC is an agency.
Can you tell us the difference? I think he can
CAPEA.
tell us, the person who is, you can tell us what the difference of CAPEA ASMAC. Even me, I'll be happy to know. And why are you not having one?
CAPEA and ASMAC are two bodies, two distinct bodies that are the ones who are governing the agencies that are all members in the different agencies. Sorry? The difference between ASMAC and CAPEA. We're basically the same, but we have different members in. They have their members and we have our members. Is that correct, Chairman?
By what they mean CAPEA has some people do the same duties.
Yes, yeah. we do carry out the same functions. Definitely, yes.
So thank you. I think now we are well informed. You can
Very
continue.
well. Okay, so I'm going to present our amendments, our proposal of the amendments, which are clause by clauses. We're going to start by clause number 6G. Clause number 6G of the bill be deleted and substituted, therefore, for the following. Development and implementation of collaboration with private employment agencies and other stakeholders as return and integration programs for migrant workers. This is paramount because most of the agencies are the ones with the database, the database of the migrant workers, and they'll be better placed to inform the government and any other agencies of the employees that have gone outside the country, and they'll be better placed to inform the government of the same. I'm going to go to clause number 16.3. The clause number 16.3 of the bill be amended and is inserting the following provision immediately after the existing provision. Provide that where a private employment agency has submitted a complete application for renewal prior to the expiry of its certificate, and the authority or committee fails to determine the application within the valid period due to administrative delay not attributed to the agency shall not be deemed to have contravened subsection 2 and may continue to operate pending determination of the application. This protects agencies from penal consequences arising from administrative delays consistent with the fair administrative action under Article 47 of the Kenya Constitution. Equally, we are also against clause number 13 and 14, for they are duplicating roles of the national government of NEA, and the county government. We are therefore requesting that the entire clauses be deleted in its entirety. On clause number 17.4a, clause 17.4a of the bill be deleted and substituted therefore for the following. We're satisfied and the application complies with the Act, approve the application and direct the Director General to issue a certificate of registration in the prescribed form. Upon issuance of Director General shall furnish the registered agency with the applicable rules, guidelines and regulations issued under these articles. It should be in order because most of the agencies, they suffer because they are not told who are the regulations and the are supposed to be. They assume that the regulations are supposed to be known by the agencies without explaining it to them. On clause number 17.7, the clause of the bill be deleted and substituted therefore with the following. A certificate of registration may be transferred with the prior written approval of the committee upon application in the prescribed form, subject to the vetting of the proposed transfer in accordance with this act. Upon approval, the Director General shall issue an amended certificate, and the transfer shall assume all obligations attached thereof. Our justification is because facilitation lawful business continuity while maintaining regulatory oversight. On clause number 17b, the clause of the bill be deleted and substituted therefore the following. A certificate of registration shall, unless cancelled earlier, be valid for a period of 2 years for the date of issues. Reduce administrative burden aligned with the standard licensing cycle. As we are always told that the agencies are supposed to renew their license within a period of 1 year, we therefore request that the period be extended to 2 years so that they can be able to, because the amount that they are supposed to raise is quite a huge amount, and therefore within within a 2-year period, it will be fair enough for the agencies. On clause number 18.1c, the bill be deleted and substituted with the following. Financial capacity of prescribed in this act or in regulation made thereof. Ensure transparency and accountability through statutory and regulation prescription. We are therefore requesting that the amount that's supposed to be any financial capacity or that is supposed to be prescribed in this act, and therefore they should not be given an ambiguous figure that's supposed to pay. On clause number 18.1d, the clause of the bill be deleted. Market viability is a commercial determination and not a proper criteria for licensing. In this clause, it entails that the agencies are supposed to come up with markets so that they can be issued with their license. We're therefore requesting that the entire bill be deleted. Market viability is a commercial determination and not a proper criteria for licensing an agent. On clause number 18.1e, the clause 1e of the bill be deleted and substituted therefore with the following. A duly notarized undertaking for net liability for its acts of omission, which liability shall be secured under the bond required under section 19. Avoid duplication and aligning liability coverage within the statutory bond. On clause number 19.3, clause number 93 of the bill be deleted and substituted therefore with the following. The security bond shall not be sourced from the paid up share capital of operation capital of the private employment agency and shall be obtained from a separate and identifiable source. Clarifies financial requirements as regards operational capital. I'm going to clause number 22.2 of the bill, amended by inserting the following new paragraph immediately after paragraph B. For the avoidance of doubt, a registered private employment agency may operate more than one branch within the same county, subject to compliance with prescribed requirements. Because of the current bill, the current proposal stipulates that an agent shall not operate to more than one county. We're therefore requesting that a particular agent can operate within different counties and be given within the same license. On clause number 30, subclause 1 of the bill, a foreigner employer or a foreign private employment agency shall not undertake recruitment activities within Kenya except through a formal collaboration with a private employment agency duly registered in Kenya, which shall be disclosed in the recruitment documentation and ensure compliance with this act. This is to safeguard the private employment agencies in Kenya. On clause number 33, a private employment agency shall be deemed to be a party to a contract of employment between a migrant worker and a foreign employer and shall not incur joint and several liability for the performance of such contract except where the agency knowingly misrepresents or withholds material information relating to the employment. This to protect the agencies back in Kenya, whereby the foreign agency should be held liable for the atrocity maybe they have committed. On clause number 39.2, a clause of the bill be amended by inserting the following provision of the end of therefore. Provide that any seizure shall be accompanied by a written inventory signed by, provided by any seizure shall be accompanied by any written inventory signed by the inspector and representative of the agency, and a copy therefore shall be issued to the agency. This is when the police, they always come to raid the agencies. They're supposed to provide the agencies with the inventory of all the particulars that they have collected from the agencies. Clause number 42.1, the bill be amended by inserting the following provision at the end therefore. Provide that where the medical examination was conducted by an approved medical practitioner, any liability arising from negligent certification shall attach to such practitioners and not be transferred to the agents. Clause number 42.2 of the bill be deleted and substituted therefore with the following: that agency should only provide the relevant information to the relevant government authorities that will help in the repatriation process involving the Kenyan embassies in host countries, and the agency should not be the ones that are repatriating the bodies back to Kenya. On clause number 42.3, clause on the bill be amended by inserting the following provision at the end thereof: provided that where termination is attributed to fault of the migrant workers, the private employer agencies have recover reasonable and deductible costs incurred in the recruitment and the deployment process in accordance with the applicable law. Agencies usually face a lot of costs, and therefore when employees visit different countries, they fail to meet the expenses. Therefore, deductions should be at the reasonable cost. On clause number 46 of the bill be amended by inserting the following provision at the end therefore: provided that temporary custody of travel documents for lawful administrative purposes within the written consent of the migrant worker shall not constitute an offense. Police are usually raiding agencies, basically for holding passport and any documentation. Therefore, we are requesting that this bill should look into that and be able to protect agencies. On clause number 51 of the bill be deleted and substituted therefore with the following: a person who at the commencement of this act is lawfully operating under valid license shall continue to operate under the license until its expiry and shall apply for registration under the act prior to such expiry. That's all.
Thank you very much, honorable members and the team. So it was a heavy documented day. So I think there's a team which have not introduced themselves. If you know you have not introduced yourself, you can introduce where you are sitting. We can start from this side.
Good afternoon. I'm Nancy Wanjala. I'm from National Employment Authority.
Good afternoon. My name is Brenda Mwenda from National Employment Authority.
Good afternoon. I'm Alice Chonga from the Ministry of Labor.
This side. If you would not introduce yourself, you can put your name in hazard.
Good afternoon. My name is Lucia Kariuki from Kapea.
Thank you very much, Honorable Kivai. Now we can go to questions.
No, thank you, Chairman. It's a very quick clarification I want from the employment agencies, both ASMAC and CAPEA. Earlier on, I was having a conversation with an earlier presenter about the period it takes for your private agencies to be registered from application. In your submissions, I've not seen anything. Do you have anything to say? Are you happy with what period would you like to see? Because we had a bit of an argument with him, although he more or less agreed with me. And
thank you,
lastly, Chair, I know ASMAC's presentation was sometimes just to delete a section without telling us why. I'm particularly interested in 42.1a because it's not included in your last summary. What are you trying to cure there? 42.1a.
Mheshimiwa, any more questions?
No.
So I think the two chairmen, they are here for CAPEA and ASMAC. They will tell us the first question, and then now the technical team for ASMAC, you can talk about 41.
42.1a.
You can talk about 41. Now we can start with ASMAC Chair, Francis.
Yeah, thank you, Honorable Chair. For the question of the period, we are not happy with because we take a lot of time, and most, if you see in the registration for the past few years, from 2019, we had registered about 2,000 recruitment agencies. But if you go now to the active one in the NEA portal, you'll find only 500 active. You can ask yourself, 3/4 of those agents, where have they gone? If you look to the problem itself, you'll find that they have fallen out because of the registration. When you apply for renewal, you take about 6 months, so you lose the partners on the other side, and you lose the business because either they go to the other country. Actually, you cannot open a restaurant and you wait for your son to finish school to come to manage. That's what happened to us. So we are not happy. We would like that it renew automatically, just like the county council, county licenses. You continue with the business. If there is any issue, let the authority come in and look at the point. Thank you.
Thank you. Juma, Chairman Kapea.
Thank you, Chairman. My name is Sarah Juma, Chairman Kapea. If I didn't get the question clearly, I think it's, are we happy on the period of renewal or registration of the certificate?
Let me be clear. In the submission of one of the presenters, he submitted that it should take 45 days.
Yeah, thank you, sir.
And then I suggested no.
Yeah, to be honestly, I want to be fair. Regarding the NEA regulation, they are opening their portal 3 months before the expiration of the license. So if sincerely you are going to start your renewal process within that period, definitely you are going to hit the time of renewal even before your license expired. I'm saying this because I've been doing the same and I've been getting the license
What
on
about
time.
a new application?
Well, in regards to the new application, it will depend now on the applicant because he need a lot of guidelines because it's not easy. They have to go vigorous, what we call background reports, and actually they need to get guidelines from the National Employment Authority itself so that they can do the needful.
I think we need to be clear, Mheshimiwa. Only the State Department, they can tell us about the new one. The new one. Maybe you can come here and share some lights about the new one.
Thank
you. Thank you, Chair, and thank you, Honorable Member. I think with regard to the period which it takes for a new applicant to be registered under NEA, I think it also depends on how diligent the applicant is in meeting the requirements. If they are slow in submitting the required documentations to NEA, then again that affects the timeline. So having hard and fast rules as to the period that has to be taken may be a bit tricky because some of it also involves background checks by security agencies on the profile of the directors and the managers who are going to run that agency. And sometimes investigations take long. And some of the agencies involved, you know, do not work by way of documentation. I'm speaking about the NIS, who have to either give a no objection or, a denial. But they are not subject to control of some of the agencies here. Thank you.
Yes, Honorable Kivai.
Chair, I'm not being guided. Right now, we have the proposed bill talks of 14 days, which I challenged. The presenter talked of 45 days, and we were almost reached 30 days. How do you guide us? You can't leave it open-ended like that.
Thank you, Chair. Thank you, Chair. I think I may need to interact more with the submissions that have been made by the various organizations and also reflect that against what we were also proposing as a ministry. As I've said before, we have a position that we are making on that particular issue on registration so that we find the best way forward. So I think we would be coming up with a comprehensive response on that within our submissions, which we are going to make very soon. Thank you, Chair.
So thank you very much, Asma, Francis.
Yeah. On question 2, where our honorable member asked about delete section 42(1) on repatriation, we need it deleted completely. The reason I can give an example. If you take your brother to work in
it's not on repatriation.
Yeah. What's on it?
42(1)A.
Yeah,
talks of medical examination.
Or medical examination.
My question is, what are you trying to cure there?
Yeah, to protect agents. Yeah, can you answer that?
On the reason we put that one, we are putting the blame on the, or rather the cost to the of repatriation to the agent. Yet this, by the time this migrant worker was leaving the country, a medical practitioner had confirmed that this guy is medically fit. So it's the issue of the medical practitioner who said that this person is fit, yet they were not fit. So we wish to have the cost taken now back to the medical practitioner instead of the agent. Thank you.
Are we in order there? Thank you. Any other concern? Proceed.
Then on the issue of registration and renewal, our biggest challenge is on the background check. So maybe we can propose, instead of having this background check when you are doing the renewal, can it be something that's running across the year? As I operate, maybe someone still keeps on checking on how I'm doing. Once I submit for my renewal, they just give a report immediately. Thank you.
Thank you. Thank you. Having no another business, we can only remain with the State Department for Labor. We need to share more lights when we are bringing the bill. So others, you are being released. There's a tea outside there. You can also exchange your contacts as you take the tea. Thank you very much, and thank you very much for coming. Thank you.
Thank you.
So I think Mwanzia from State Department of Labor, when do we expect? Okay, I think also media, we also released you. Media, you are released. I think you have done a good job. You have taken something. So feel released. Bye.